Good evening, everyone. Welcome. I'm delighted to welcome you to our roundtable organized by the Britain Europe think tank and the Knowing Our Rights project at Brunel University London and Brunel Law School. We have a wonderful range of expertise with us tonight. And so we will be tackling some very pressing questions surrounding the fate of fundamental rights and liberties in the UK after Brexit. So we will be asking what is going to be the fate of rights that we enjoy under EU law, for instance, once we have exited the European Union, such as workers' rights, data protection, the right against discrimination. We will be asking whether the residence rights of EU citizens will be protected, and if yes, how can we make sure that they will be enforced in a not very cumbersome way? And these are very timely questions. We have a number of clauses related to EU residents' rights and EU citizens' rights more generally that are debated at the Lords at committee stage next week. And so we're very privileged to have with us tonight Alex Horne, for instance, who is the Deputy Legal Advisor at the Joint Committee on Human Rights and has been heavily involved in the research that led to the development of one of these clauses proposed originally by Harriet Harman. And we're equally delighted to have with us Professor Sionaidh Douglas-Scott, who has also been involved in this process, not least by providing oral evidence to the Joint Committee on Human Rights. At a more theoretical level, we will also ask whether the Eurosceptic currents that are seemingly taking us to a quite hard Brexit, it must be said, whether they will retain their full force after the triggering of Article 50. And if they do, should we anticipate further attacks upon the UK's commitment to international law and transnational law, potentially fueled by ongoing Euroscepticism and increasing isolationist trends? We will ask more specifically whether Brexit has opened Pandora's box or maybe created the perfect storm, so to speak, in terms of a potential attack upon the European Convention on Human Rights and potential repeal of the Human Rights Act. The focus here will be on the fate of these two important human rights instruments. So we will ask, does Brexit risk to trigger a process that will eventually lead the Conservative government to give effect to its pledge in the 2015 manifesto to repeal the Human Rights Act and even possibly to take the UK away from the Convention? Or conversely, could the Human Rights Act and the European Convention on Human Rights obtain a whole new meaning after Brexit as the key human rights instruments in the UK at a time when we will no longer be able to rely upon EU law and the jurisprudence of the Court of Justice of the European Union for protection? Now, a concern for the future of the Human Rights Act and the European Convention on Human Rights in the UK goes to the heart of the Knowing Our Rights research project that we are delighted to launch here tonight. The project aims to deepen our understanding of how the European Convention on Human Rights operates in the UK and to facilitate evidence-based evaluations of its impact upon life in the UK, crucially from the viewpoint of the wider public. So there is a strong public engagement aspect in this project. Only a couple of weeks ago, we have had 6 schools from across London debating some very controversial human rights issues at Brunel in our first human rights debating competition, such as prisoners' rights, for instance, or the burqa ban or online privacy. In the next 2 months, we're visiting 30 schools across London and in other parts of the UK, in the Midlands and the north of the UK, in collaboration with the youth organisation Shout Out UK. We will be shortly announcing a quite exciting panel discussion at the front line on the conflict between the right to privacy on the one hand, freedom of expression on the other. Professor Julian Petley, Head of Journalism at Brunel, is leading on this. We will be also shortly launching a human rights film festival in key venues in London, and a date for your diaries is May 31st at the Regent Street Cinema. when we will be screening the lost honor of Christopher Jeffries, with the subject of that film being present and answering questions in the end. I should add that on March 14th, we hope that many of you will actually be able to join us at Brunel this time for a public lecture and the official launch of the project there at the university with the new director of Liberty, Martha Sperry QC, who will be raising the alarm, from what I hear, about the challenges ahead with the protection of fundamental human rights in the UK. Human rights will be the fight of our generation, she's quoted as saying, upon taking her new role last June. We're equally excited to support and closely collaborate in this project with our refugee crisis project led by my good colleague Professor Alexander Xanthaki, which includes a very timely research seminar series on refugee rights and activist humanitarian, I should say, trips to Athens in particular to support the refugees in the reception centers there. And some of our students present here today were in Athens just last week, if I'm not wrong. Now, we do all this, or we're trying to do all this through our many experts at Brunel and outside, and are currently discussing potential collaborations with the UK in a Changing Europe, with Liberty, with Fair Trials International, and the Bingham Centre for the Rule of Law, among others. It goes without saying that we very much look forward to collaborating closely with you in the weeks ahead and the months ahead, and I should say in the years ahead, as we're facing significant challenges with human rights and Brexit. I must add, coming to an end, that the project is funded by the Open Society Foundations and the Open Society Initiative for Europe, and we're very grateful to them and the many people at Brunel and outside who are behind the project for all the support that they have provided. Professor Petley in particular, with whom we are leading in this project. Big thanks also go to the British Academy for being quite exceptional hosts tonight in this very prestigious, very inspirational surroundings. I will now close by noting that we really have exceptional expertise in the House tonight, both in the form of our roundtable participants, and I'm very thankful to all of you for being here and supporting us, and our host, Joshua Rozenberg QC. And Joshua is undoubtedly the leading legal commentator in the country and an expert facilitator of complex events like tonight's roundtable. And I say it's complex because we're faced with a series of challenging questions, and a number of experts and other participants are very willing, I don't have any doubt, to provide very detailed answers to all these questions. But I'm sure Joshua will make sure that everybody is to the point and concise, everybody except for me. I have to say that I probably abused my privileges here. So I would simply like to thank you once again for engaging with Britain in Europe and the Knowing Our Rights project. And I will now leave us in the very capable hands of Joshua. Well, thank you.
Thank you very much indeed, Dimitrios, and a welcome to everybody here. Housekeeping, we have Wi-Fi here. That is the username. It says 10 to 11 CHT, Carlton House Terrace. You can find it very easily. And the password is hospitality. And the hashtag is our rights. From that, you may infer that this entire meeting is on the record, it's being video recorded, it will be published, it's all entirely public. This is not Chatham House, it's British Academy. We have 3 topics to discuss, but I'm not going to be too worried if they merge. The first is our agenda really is to start with the recent report of the Joint Committee on Human Rights. As you've heard, Alex is the Deputy Legal Advisor to that Joint Parliamentary Committee, and Sionaidh Douglas-Scott here was one of the witnesses who gave evidence to that committee. And it's not that we particularly want to critique their work, but that was a very good introduction to the whole issue of human rights and Brexit. And it just gives us a bit of a framework to start. Then we've got Brexit, the ECHR and the UK Bill of Rights, with another list of people who are particularly interested in this subject. And thirdly, we've got criminal justice and human rights after Brexit. And what I've said to Sionaidh and Alex is that I don't particularly expect them to have prepared detailed papers. We're going to start with a bit of a discussion between us about these issues. And it is really an extraordinary thing, because when Dimitrios first said, well, let's talk about Brexit and human rights, my first reaction was, well, hang on, Brexit is the Luxembourg court and human rights is the Strasbourg court, and even I know they're different. What's it got to do? What's Brexit got to do with human rights? And then, of course, as Dimitrios says, you've got this extraordinary situation whereby the government has put off until after the next general election anything to do with reform of human rights as such. We are told, we're not sure we believe this, but we're told that there will be a manifesto commitment at the next election. Now that may be a way of promising something to come, or it may be a way of kicking something very much into the long grass. You know, if we can get as far as 2020, we're doing pretty well. So who knows? And as Dimitrios says, you've got this extraordinary thought that we may think that leaving one European or pan-European institution is, misfortune, but to leave two would be complete carelessness, or whatever the phrase is. Or you may take the view that, the only reason that we were in the ECHR was because we thought if we left the ECHR we might have to leave the EU, and if we're leaving the EU anyway, we might as well leave the ECHR. So, anything's possible. It really is quite an extraordinary situation to be in. Let's talk then about this report, The Human Rights Implications of Brexit, which was published just before Christmas by the Joint Committee on Human Rights, House of Commons, House of Lords. In summary, the MPs and peers decided to hold the inquiry because they wanted to assess the impact of Brexit on human rights. They had an open-ended focus. I think the main topic that they dealt with was residents' rights, EU nationals in the UK and UK nationals in other EU countries. I think we'll start with that. And Alex, do you want to just very briefly summarise what the committee concluded on these topics? What the question that was asked was, well, what happens to people in the UK who are from other EU countries once we leave the EU and they no longer have a right to stay, and what happens to UK nationals in other EU countries? That's the question.
Yes, I mean, it is. I'll start. First of all, I should make a very brief disclaimer, which is I'm both Deputy Legal Advisor to the committee. I'm also a parliamentary official, so you'll take it that I'm making no party political or otherwise political comments during my comments here this evening, but I'm very happy to speak to the report of the committee. The report considered four main questions: the question of residents' rights, the Charter of Fundamental Rights, the proposed Great Repeal Bill, and human rights clauses in trade agreements. Although, as Joshua said, it started off being a very open-ended project, we quickly came to conclude that there was so much to look at here that, as the report says in its introduction, this is an interim report, and the committee may well come back to some of the other subjects later. On the question of residents' rights, we quickly became aware that this was a significant issue. Of the submissions that we received, most of those that were not sent institutionally came from individuals who were affected, and they raised a whole series of concerns. Some people were concerned that they might wish to retire to Europe and would be unable to do so. Some people were concerned that their partners were European nationals and that they may not be able to stay in the UK. People were very anxious, and the more we looked at this, the more complex it appeared to be. Our inquiry also coincided with an inquiry by the EU Justice Subcommittee, which Sionaidh also gave evidence to. I remember hearing this, and again, they were looking at acquired rights and whether or not these the the rights of nationals, amongst other things, would be safeguarded in international law, and it quickly became apparent that that was unlikely to be the case. We focused rather more narrowly on the question of human rights and whether or not the individuals concerned would be protected by Article 8 of the European Convention on Human Rights. And the question was far from clear. And what did become very obvious was that it was one that, if the government had thought of, they'd reached no conclusions on, certainly on the numbers of people that would be impacted by this and how they were going to deal with it. And so the committee came to two real conclusions. The first is that they felt that there was a moral obligation to people, which I think is the obvious point, and one of which has been in the newspapers for quite some time. But the second was this point that, in reality, Article 8 of the European Convention on Human Rights requires individual treatment. So if, in the very unlikely event that no agreement was reached, the UK started trying to negotiate over the rights of EU citizens in the UK, and indeed vice versa, because the EU countries involved are all signatories to the convention, it was far from clear that it would be possible to ask anybody to actually leave. And if you did try and do so, then each case would have to be assessed on its own facts. You'd have to look at the question of whether or not the person concerned had settled in the UK, what their family life was like. And given that the government had had so many problems in terms of the question of deportation generally under Article 8, it looked to us slightly unlikely that this was a practicable solution for them to negotiate over this issue. So I think those were the two main conclusions that we reached on that particular subject.
Okay, well, let's pause there, because this is the first point this evening at which we're going to say, well, it's not clear, we don't know, it all depends, we're going to try and find out, nobody really knows. But let's just pause for a moment to sum up what Alex has said. I never, of course, go anywhere without my Human Rights Convention. Article 8, right to respect for private and family life. Paragraph 1, everyone has the right to respect for his private and family life, his home and his correspondence. Article 2, of course, there are various exceptions to that. And so the question that the committee was looking at is, if you chuck out these EU nationals when the UK leaves the EU, is this a breach of their right to respect for their private and family life? And what Alex has said is it all depends. It depends on the, well, what does it depend on? Shona, over to you. What does it depend on?
Okay, well, can I just say a few preliminary remarks first? I mean, firstly, thanks to Dimitrios for inviting me here. It's a really lovely environment to be speaking in.
Yes, likewise, I would also like to thank Dimitrios.
And just going back to something you said earlier, Joshua, about human rights and the EU, and we, of course, have the ECHR, and maybe human rights isn't the most likely thing to associate with the EU. I've been working on human rights in the EU since about, it's embarrassing to say, about 1990, a long, long time. And for those of us who are old enough to remember a time before the Human Rights Act came into force, before the European Convention was incorporated into UK law, actually EU law provided a rather valuable, I'd almost say mini Bill of Rights, particularly in the area of discrimination law, equal pay for equal work, work of equal value, and I'm sure we'll come on to that later. But so I've always felt very aware that the EU can be seen as partly a human rights organisation. And when there was talk of a referendum, and possibly of the UK leaving the EU, that was one of the first things I started to worry about. What is going to happen to human rights? And I find it interesting that in the Miller case, a major centre of gravity and point of focus for that litigation was the element of rights. But Joshua, you've moved us on to this question of residence rights, and in a sense that's really the most pressing thing right now, because we have these over 3 million EU nationals living in the UK, very worried about their situation. And what I'd say I largely agree with the committee's report. And one thing I really welcomed was a strong statement at the outset, regretting that the UK government ministers had not been more forthcoming with information. the Lord Chancellor had declined to attend, and that the information we got from Liam Fox was extremely limited. So we don't have a great deal of information from the government on this. All we have is a statement that EU nationals can be used as bargaining chips, which is, I think, regrettable to say the least. Lots of other nice messages being given out, moral dimension to this, but morality isn't enough here, because most of us, a lot of us around here are lawyers, and these rights that EU citizens currently have are enshrined in EU law. That's going to be taken away, and we're looking at other avenues of course, the European Convention. Politicians may or may not be moral, but if there are rights, legally enforceable rights at issue, that is a very, very important factor, and I think it's important to remember that.
Can I press you though on this point? You know, we have EU citizens in the room who may not be UK citizens. They have private and family lives in the sense that they live here. We are assuming that the convention will still apply when we leave the EU. I think that's a fairly safe assumption. We are speculating, and it is pretty speculative, and I would perhaps suggest pretty unlikely that the UK government is going to say, out you go. But nevertheless, it is talking about this being a bargaining counter, a bargaining chip. So let's say that the UK government doesn't reach a deal with the EU negotiators on the rights of EU nationals in the UK and says to them, or some of them, well, out you go. Are they going to be able to rely on Article 8?
Well, some will, some maybe not. It will depend on their particular situation. I think those EU nationals who have been in work for at least 5 years and are able to provide evidence of that will be better placed than others who have not been working, family members, spouses. And those are the ones who will particularly want to look to Article 8, and it will be important for them to demonstrate that they are sufficiently embedded within the UK life in order to found their claim on Article 8. The more embedded they have a family here, they have a family life here, children in nursery, things like that. Even if they are not personally working, the stronger their claim will be. But as we know, Article 8 is not an absolute right, and so it will be open to the UK government to try to say that sometimes there are limitations that they can justify. And the less embedded the EU national is, the easier it might be for the UK government to make that claim.
Yes, I didn't read out paragraph 2, but it does say that there can be, it does imply there can be interference with this right in accordance with the law, if it's necessary in a democratic society, in the interests of the economic well-being of the country.
Yeah, yeah.
So that would be an exception. Can I, at this point, just see if anybody around the table, ideally somebody with a legal background, can contribute to this exploration of whether Article 8 could be used against the, I hope, theoretical risk that the UK government might decide to deport people. Yeah, Anthony.
Well, Article 8 always can be used by the government. The question is how far it would go. But if I can just add an extra dimension to it, I imagine there will be agreement on this point, but the agreement may relate to a sort of cut-off point, like the date of the referendum, and then some of the issues that we've been talking about will still apply to people who arrive after the date, where it will be easier for the government to maintain a position. But none of this is conclusive, is it? So that it will still be difficult, won't it?
Okay, anybody else want to chip in? Yes, Merris.
Well, I've been looking at this quite a bit, the justification for it in particular. And so it's not an absolute right, so they have to show that the interference is necessary in one of the interests set out in the right itself. So it has to be based very much on parliamentary debate. Has Parliament considered this issue very carefully? What are the reasons that are being given? Or it might be based on the referendum result, which is going to be very difficult given there wasn't a specific question about the rights of EU nationals living in the UK.
I'll come on to Parliament in a moment, but Mary, do you want to chip in there, please?
Yeah, it was actually on this question really of Parliament and the political perspective of this, because this is obviously and always has been a hugely political issue, and of course immigration was one of the key drivers in the referendum. So I think there's a really quite frightening mix here, and because I'm not a lawyer, but what you've all said around the table, that this is not absolute anyway. I mean, I think this could be a really difficult area. I mean, given the politics and where the government's coming from and what happened in the referendum. So I just think we need real vigilance about this.
Okay, look, here is a story in The Guardian today, and it says, the headline is, Labour Sends Hope of Brexit Guarantee for EU Citizens in the UK. First line, Labour is increasingly optimistic it can force concessions from the government over the status of EU nationals in post-Brexit Britain after securing cross-party backing for an amendment to the Article 50 bill currently before Parliament. And it goes into tremendous detail about that. So let's look at Parliament. We have the European Union notification of withdrawal bill before the House of Lords at the moment. And and amendments are to be considered, Monday and Wednesday? Monday and Wednesday of next week. Now, let's start, first of all, with an amendment put forward by Harriet Harman on behalf of the Joint Committee on Human Rights.
That's right. So in the Commons, Harriet Harman laid an amendment on EU residents' rights. That amendment, I think it's fair to say, is sponsored by the committee. Procedurally, there's no way of having committee-based amendments, and it's right to say also that not every member of the committee signed in support of the amendment, but the majority of members of the committee have signed in support of the amendment, and it was drafted by lawyers on the committee, well, mainly by me and a couple of others, in order to deal with that. Would you
I'll read it out. Insert the following new clause. Nothing in this Act, I'm reading the right one,
yes.
Nothing in this Act shall affect the continuation of those residents' rights enjoyed by EU citizens lawfully resident in the United Kingdom on the 23rd of June 2016, date of the referendum, under or by virtue of Directive 2004/38 EC, after the United Kingdom's withdrawal from the European Union. So the idea is that nothing in the Notification of Withdrawal Act should affect the continuation of residence rights of people who were here at the time of the referendum. Just on the drafting point of this, well, nobody would expect anything in that Act to affect the residence rights.
It's interesting you say that. And the drafting is actually predicated on a submission made by David Pannick in the Miller case. If you go to his submissions, I think at para 37 of the judgment, he makes an interesting analogy of the notification being like the firing of a gun. And the eventual result is that the bullet hits the target and these rights fall away. And as Sionaidh indicated at the beginning of this session, the Miller judgment is very much about rights. And so we took the view in drafting this, that in drafting it in this particular way, it works as a savings clause. So at the end of the 2-year period, if no agreement has been made in relation to the residence rights of those people covered by the clause, then those rights would continue in force until or unless some further legislation was enacted.
All right.
And so that is the...
Okay, well, that's a very fair answer to my scepticism there, but perhaps we won't go any further down that road, because you, Alex, tell me that the House of Lords is coalescing around a different amendment, which has been put forward in the Lords and is slightly differently drafted. And what it says is, in negotiating and concluding an agreement in accordance with Article 50, paragraph 2 of the Treaty on European Union, Ministers of the Crown must resolve to ensure that citizens of another European Union or European Economic Area country who are legally resident in the United Kingdom on the day on which this Act is passed are not disadvantaged in relation to their right to reside and work in the United Kingdom or their potential to acquire such rights in the future. So we have a different date. We have the date in March, next month, the date in March when the Notification of Withdrawal Act becomes law, we assume. And it says all that's necessary to comply with this drafting is that ministers of the Crown must resolve to ensure that EU citizens and EEA citizens who are legally resident in the UK on that date are not disadvantaged in relation to their right to reside and work in the United Kingdom. What's the significance of this wording compared with the wording that we've just talked about?
Okay, I mean, I should say at the outset, we don't yet know which of the clauses is likely to be either voted on or the lead clause. The clause that was sponsored by the Joint Committee on Human Rights was the lead clause in the House of Commons, and the various whips will have politically reached a conclusion that this was either the most pragmatic or the most palatable or whatever it might be. Happily, as officials, we're not involved in that particular debate, but that was the lead clause then. The speculation in The Guardian today is that there's some move towards this particular clause, whether that's because of the date or some other reason, I don't know. It's noticeable that although this clause has been tabled by the Labour Party Brexit spokesman, it's also been signed by a Conservative member, or at least this is The Guardian's report, and I think Joshua has identified the main differences. I mean, one of the things that's worth bearing in mind practically in relation to any of the clauses, and Meg Russell wrote a good piece on this yesterday, is what actually happens with clauses. And I mean, even if the clauses are drafted by lawyers in Parliament, in reality, one of two things tends to happen. Either the government concedes on the principle and they come back and make a statement in the chamber that they will do whatever it is that is being asked of them, and that is considered to be sufficient. Or, where that's not considered to be sufficient, they say they accept the principle and they go away and draft a clause of their own, and they'll have their own parliamentary council do that. And those are the experts in legislation.
So it doesn't matter too much what the clause says. The real question is whether the government will accept any sort of amendment to this short bill currently before Parliament, which is designed in some way to tie its hand, to affect the negotiations, to perhaps hinder its negotiating position if it has to go into the negotiations having conceded that it's going to allow these rights to EU citizens in the UK. Let's talk about that then. Let's talk about the political realities. You can't talk about that as a sort of public servant, but let's talk about the political realities, the importance of it, the effect of this if it's happening, the likelihood of it's happening, and the consequences if it does happen. Who wants to contribute on this? Somebody who hasn't spoken so far. Do you want to? Yes, Dimitrios.
Yes, I think perhaps it would be quite unlikely in my mind for there to be a sort of mass deportation of EU nationals. I do wonder, however, if it's more possible that there would be some sort of income level that would be required for someone to continue to reside, similar to yesterday's Supreme Court judgment. And if that was the avenue through which the UK could perhaps get rid of some of the citizens, then how would perhaps Article 8 apply in that case? And that's a question that I'm asking. I'm not sure I have an answer to that. But if that's the avenue that will be followed, is there any ECHR? Yeah.
Merris, do you want to comment on that?
Yeah, I think there is. I think there is a danger of distinguishing between groups of EU nationals who are living in the UK, and in which case there's another convention right which will become handy, which is Article 14, which is non-discrimination in enjoyment of the convention rights, and that will probably be one of the most important rights that we have in going forward, because it's not only in relation to EU nationals who are living in the UK, but it's in relation to all kinds of other things the government's suggesting. It will have different treatment for different industries and different treatment for different exporters. And whenever I hear different treatment or special treatment, I start to think discrimination.
Yes, Article 14 says the enjoyment of the rights and freedoms set forth in this convention shall be secured without discrimination on any ground such as sex, race, colour, language, religion, political or other opinion, national, social origin, association with a national minority, property, birth or other status. But of course, it applies only to a right that is secured by the Convention, hence Article 8. It's parasitic on Article 8.
But that could be relevant when it comes to a cut-off point, because if you choose the date of the referendum or the date of the EU withdrawal bill, either way it's somewhat arbitrary, and the whole group could then say, well, this is discrimination on the basis of Article 14. We have Article 8 rights, but why do those people get them and not us, because you've chosen this cut-off point?
So Geoffrey Nice.
Was there any understanding as to the mechanism for sending people away, if they had to be sent away, how many there would be, what appeal process there would be, and what resources would be required?
Well, it's an interesting point you make. I mean, when we spoke to the Minister, I think the Minister was very much of the view that the idea that anybody would be asked to leave was enormously doubtful. That this is a discussion about a negotiation as opposed to an idea that there are going to be deportation of real people. Certainly, the impression the government gave us was that this was all entirely speculative on our part. But the problem is that to have a negotiation, one has to actually be able to do what it is that one says that one is doing, and it's far from clear that that is feasible given the discussions we're having about Article 8. And the point that our chair, Harriet Harman, made in a letter to the FT yesterday that was signed by 47 members of the House of Lords was that the court system itself, if you ended up with even 10% of the people that were affected by this, or even 1% of the people who are affected by this, bringing cases to the courts, they would probably be overwhelmed. And each of these cases would have to be determined on its own facts, because you have to consider the residence rights of the person concerned and their the way that they've settled in the country and their family relations and everything else. There's no bright line test that you can make to simply say you've been here for 18 months and therefore you must go, whereas this person's been here for 2 years and he can stay. That's not the way that the Article 8 rights work in practice.
Yeah, I mean, you say this in paragraph 42. It is plain that in the unlikely event that the government sought to deport EU nationals, there could be the potential for significant, expensive and lengthy litigation leading to considerable legal uncertainty for a prolonged period of time. Such claims could potentially overwhelm the courts and tribunal system.
And I think that must be the case. You can see, I think, in the preceding paragraph that the government say that they've made no estimation of this because they don't think it's going to happen. But if they don't think it's going to happen, then it's very difficult to know what the negotiating position is with the other EU states. And of course, all the other EU states find themselves in the same position, because if they wish to tell the UK nationals that they can no longer stay, they have exactly the same rights under the Convention.
Go ahead.
Yes. We do know that your point about the courts being overwhelmed by such cases, pretty powerful evidence was given by the President of the Tribunals and the immigration lawyers to the House of Lords Constitutional Committee before Christmas, which indicated quite clearly that the immigration system, immigration law, the Home Office is in a complete mess. And the idea of introducing changes and trying to deal with 3 million people who potentially have rights that may be justiciable would just bring the whole system to a complete stop. I mean, I can give you details, but it is there in the record of the oral hearings for the Constitutional Committee. It's probably not practical, and it may be that the government may need to accept an an amendment on the clause just to escape from its own rhetoric.
Yes, it's interesting. I mean, the paragraph 41 that you refer me to, this is the government saying we do not expect there to be legal proceedings of the sort that have been outlined. We expect this to be a matter of speedy agreement. So perhaps this is all a red herring. Perhaps the government actually wants to be forced by Parliament to accept an amendment which means that it goes into the negotiating room saying, well, you know, we're not going to chuck these people out, so you better allow UK people to stay, and let's go on and talk about, you know, what the real issues are. Is that? Yeah, Dimitrios.
on that, I'd just like to observe that it is quite obvious that the Joint Committee has unearthed myriad complications. You can easily tell that, a plethora of complications, let alone the ethical and legal hurdles to moving forward with potentially moving EU citizens away from the country. So I'm wondering, has any evidence been presented to the committee that suggested that there are some very significant benefits in moving forward in this direction, and in not recognizing at the very least the rights of citizens now unilaterally and potentially winning hearts in forthcoming negotiations? So I think that argument might be an important one as well.
Well, I think the two arguments that are effectively made in relation to this. The first is the argument that's always been made by the government consistently, which is that this forms part of a negotiation, and that there are people in the EU who will not make the same sort of statements that they're being asked to make in relation to EU nationals in the UK to those UK nationals in the EU. And that has been a consistent statement throughout. The other issue, I suppose, and this is very much a political question, which I'm not going to dwell on particularly, but is going to be the date. The cut-off date, the further forward it is in the future, and I think it's now, whether it's the 23rd of June or whether it's March is probably less arguable. But certainly I know, and Sionaidh, you may have made the point that it might be when we actually leave the EU, and I think the concerns that people have about that is that will incentivise people to come to the UK before that cut-off date. And obviously politically that has ramifications. So there's some difficulty, I think, for the government there in terms of how they deal with that.
I want to move on. Yeah, Mary, go on.
Thank you. I've felt with all of this stuff about UK nationals abroad and EU nationals here, a lot of it is actually, this idea that there's going to be a lot of deportations just simply is not going to happen. It's a rather strange negotiating strategy, and basically I think to maintain the status quo. And I think maybe we can argue legal points about this, but there is actually just the fact that it's not politically possible to do it. On the scale that it would need to be done, and I just think it's one example of, there are others of this kind of thinking, and it's very difficult because it's not kind of rational and sensible behaviour in a lot of ways.
Well, let's move on then to something slightly more rational. Let's move on to another legal issue, and that's the Charter of Fundamental Rights, proclaimed in 2000, given legal status in 2007.